All right, our next is tab number 6, which is case number 2014-705. This is in the supplemental staff report. This is Henry Campaign Fund of Ronald Woody Cheek for Judge Executive, Spencer County, Kentucky. Ronald Woody Cheek, candidate treasurer, alleges violations of KRS 121.160, KRS 121.180, and KRS 121.220. Do we have any of the parties present on this case? Yes, sir. Can you tell me your name?
Ronald Cheek.
Okay. Anybody? All right. Emily, if you will provide the board with your recommendations, please.
Thank you. This case is based on an internal staff report by registry staff dated June 11, 2014, noting apparent violations of the statutorily prescribed duties of a campaign treasurer, which include reporting requirements by the respondent, Ronald Woody Cheek, who's a candidate for Spencer County Judge Executive and the treasurer of the Cheek Campaign Fund. Based on this internal staff report, I issued a notice in staff report finding reason to believe that it appeared Cheek had not only failed to appropriately discharge duties as treasurer of his campaign, but also had failed to designate a primary campaign account for the purpose of depositing all contributions received and dispersing campaign expenditures. In response to the staff report, Cheek stated that he understood that it was his responsibility as a candidate and treasurer to be familiar with and to follow the applicable campaign finance laws. He also acknowledged that he had made several errors in complying with the reporting and record-keeping requirements of the campaign finance law during his primary election campaign, including specifically that he had received $625 in contributions in February 2014, which he deposited initially to his personal checking account in March 2014, and then transferred to the campaign account 3 days after opening the campaign account in April of 2014. That he had failed to report certain campaign expenditures before the primary due to misplaced campaign receipts, which he stated were reported after the primary by amendment when the receipts were found in the trunk of his son's car. Then Cheek also reported that there was one campaign contribution check in the amount of $200 that was lost, and another $200 contribution check that was mistakenly deposited to his personal account after he opened the campaign account, for which he then took funds from his personal account and transferred to the campaign account. Mr. Cheek included several records together with his affidavit regarding these circumstances, including proof that he had actually opened a campaign account on April the 7th, 2014. He provided copies of the campaign contribution checks that totaled $625 that were written prior to the date that the account was opened. He included his personal check in the amount of $625, a copy of that, and showed where that was deposited to the campaign account on April 10, 2014. He included he and his wife's personal checking account records to substantiate that the money that he had spent on his campaign personally was his personal money. He included copies of his campaign fund account records dating from April 7, 2014 through July 31st, 2014. At any rate, he provided me several records to show where he had made mistakes and where he had tried to correct these errors. Cheek also submitted a supplemental response on September 1st, noting that he had received one additional campaign contribution since the date of his original affidavit. This contribution was in the amount of $200, and that he had incurred an additional $6,433 in expenses on behalf of the campaign, from which he had transferred that amount from his personal account to the campaign account to pay the campaign expenses. The campaign finance law requires segregation of campaign funds from a candidate's personal funds. This requirement is set out in KRS 121.220, Section 1. That section requires a candidate to designate a primary campaign depository for the purpose of depositing all contributions and making all expenditures before the contributions are received or expenditures are made on behalf of the campaign. Even in the event that the candidate anticipates spending personal funds only, the law requires the segregation of those funds into the campaign account so that the funds may be used for campaign-related expenses only and not for personal expenses. Cheek clearly failed to initially open a campaign account when he started the 2014 primary election campaign. He admitted that he paid campaign expenses from the personal account, which was jointly owned by his wife, and that he deposited